27 states are telling the Supreme Court to get in gear, and I'm right there with them. This isn't a sleepy docket blip. It's a constitutional collision with consequences for people. California's message is blunt. If a magazine holds more than 10 rounds, ordinary citizens shouldn't touch it. Don't buy it. Don't sell it. Don't keep it for the worst night of your life. Cross that arbitrary line and suddenly you're a target. That posture treats a spring and a box like contraband, while pretending the right they undermine is just a suggestion. Before anyone hides behind jargon, remember what the court has already said. In District of Columbia v. Heller, the Second Amendment protects an individual right to keep and bear arms commonly used for lawful purposes, including self-defense. Commonly used means ordinary, widespread, familiar. Then New York State Rifle and Pistol Association v. Bruen told lower courts to measure modern regulations against the text of the amendment and our historical tradition. No balancing tests, no creative acrobatics, just the Constitution and the nation's history. Enter California's ban. The case is Virginia Duncan v. Bonta, and earlier this year the Ninth Circuit. Yes, the Ninth. Rubber-stamped the law. A state told its citizens 10 rounds and not one more. And the court nodded along like that is normal. It isn't. The common use of standard capacity magazines is obvious to anyone who has handled a modern firearm. These are not boutique curiosities. They ship with countless handguns and rifles off the shelf, the way tires ship with a car. Pretending otherwise insults reality. Now for the development that changes the temperature. On September 18, 2025, a coalition of 27 states filed an amicus brief at the Supreme Court and asked for certiorari. Plain English, take the case. The effort is led by Montana's Attorney General Austin Knudsen and Idaho's Attorney General Raul Labrador. They point back to Heller and Bruen. If an arm or accessory is commonly possessed for lawful purposes, you don't ban it. And if the government wants to restrict it, history must supply a real analog, not a seminar fantasy. Think about the stakes. If the court grants cert and applies its own rules the way it wrote them, California's magazine cap is on life support, and not just California's. Every copy and paste 10-round scheme in other capitals wobbles the moment the justices say what everyone can see. Calling round 11 contraband doesn't transform a spring, a box, and a follower into something evil. It transforms a right into a permission slip. That isn't regulation, that's erasure. And once a government learns it can erase, it rarely stops. Cue the chorus about public safety. It always shows up, as if the word safety closes the book. Meanwhile, the same voices insist these magazines are rare and unnecessary, even as the country overflows with them. They are in the hands of people who train, compete, hunt, and defend their homes. Law-abiding owners live in the real world, where capacity matters when the worst 5 seconds of your life stretch into 50. Courts pretending otherwise are doing gymnastics, not judging. And every cartwheel makes the avoidance more obvious. So yes, I'm encouraged, not because I crave lawsuits, but because enough states finally said, enough. The Constitution doesn't evaporate at a county line. Rights don't hinge on a zip code or the mood of a circuit panel. This brief asks the Supreme Court to say exactly that, clearly and loudly. So even the judges trying to dodge Heller and Bruen have to plant their feet, read the text, look at the history, and follow it. We'll walk through what this coalition argues next, what California and its allies will cook up in response, and why the Ninth Circuit's approach collapses when you hold it against the test the Supreme Court actually gave them. For now, understand the moment it's live, it's here, and it's headed upward. Let's dig into what that coalition is actually arguing, because that's where the rubber meets the road. First, the common use point isn't a slogan, it's the spine. Heller said the Second Amendment protects arms commonly used for lawful purposes. It means if ordinary people own something in vast numbers for ordinary reasons, government doesn't get to redefine it as illicit hardware. Standard capacity magazines ship with countless firearms right out of the box. They are not fringe curios. Second, Bruen's text and history test forces regulators to do homework. If you want to limit conduct the text covers, you bring forward a tradition from the founding or Reconstruction that actually resembles what you're doing now. Not a museum tour, an actual analog. The coalition says California can't do that because there is no American tradition of capacity caps that turn a perfectly ordinary piece of kit into a crime by crossing from round 10 to round 11. That line isn't a safety boundary. It's a political Sharpie that smears when courts press it. Third, rights don't evaporate at state borders. The Constitution binds states the same way it binds Congress. If a state enacts something that guts a protected right, the answer isn't move. The answer is no. The amici are telling the court to say that plainly, because too many judges act like each state gets to tailor national rights to local appetites. That's not federalism, that's fragmentation. Fourth, the property and self-defense reality. People use standard capacity magazines for lawful things, everyday range work, competition, hunting where legal, and defending their homes when seconds count and malfunctions happen. Capacity is not about cosplay. It's about uncertainty, stress, the number of attackers, or a failed round. The coalition's point is simple. The more common a tool is for lawful use, the less plausible it is to ban it outright. If the court meant what it said in Heller and Bruen, that should end the debate. Now the opposition. California and its cheer squad always lead with public safety. They intone that more rounds equals more harm, as if arithmetic writes constitutional law. Then they rummage for historical tradition, pulling out exotic one-offs, trap gun bans, Bowie knife panics, municipal rules with no broad acceptance. None of that maps onto a ubiquitous detachable magazine that ships standard with millions of arms. Next, they wave the Ninth Circuit's stamp of approval like a constitutional shield. The lower court already upheld it. They say as if en banc panels outrank Heller and Bruen. Precedent flows downhill from the Supreme Court, not sideways from a circuit trying to massage the test until it purrs. Seeking certiorari is how you stop that and restore the rule the court actually wrote. They also plead for regulatory flexibility. Give the state room. They say to tinker for the public good. But room to erase the heart of a right isn't room, it's a void. Imagine applying that logic to speech, where the government decides 10 sentences are enough for a protest and anything more makes you a criminal. Swap ink for springs, and suddenly the punchline is treated like policy wisdom. And then there's the talking point that these magazines are unnecessary. Unnecessary to whom? The intruder who brings friends. The family in a county where help is 20 minutes away. Unnecessary is a luxury word people lean on when danger is theoretical. So the lines are drawn. The coalition anchors itself in text, history, and everyday reality. California clings to fear, novelty, and a ruling that tried to outsmart Bruen rather than apply it. One side says the Constitution means what it says even when officials dislike it. The other says, trust us, it's for your safety. Just sign here and surrender round 11. You know where I stand, and you know why the court needs to say, clearly, which America we live in. That answer should not be ambiguous today. This is a constitutional fight, and I won't pretend otherwise. The coalition of 27 states isn't filing homework for extra credit. They are drawing a line and saying California's 10-round cap crosses it. The claim is straightforward: magazines that hold more than 10 rounds are widely possessed for lawful purposes. And the Second Amendment, read honestly through Heller and Bruen, doesn't let officials criminalize what ordinary citizens commonly own. You don't get to bureaucratize a right you dislike into a crime scene by redefining a spring in a box. The practical stakes are not theoretical. Real people already live under regimes where a metal box with a spring turns them into defendants, where a police report treats a standard component like contraband, and where a malfunction or multiple attackers can stretch a terrible 5 seconds into 50. Standard capacity magazines aren't talismans of danger. They are ordinary gear for ordinary citizens. When courts pretend otherwise, they aren't judging. They're auditioning for the role of safety manager. So what happens next? If the court grants certiorari and applies its own framework as written, California's cap flatlines. Copy and paste limits tremble the moment the justices say the obvious common ownership ends bans, and history does not hand you a capacity ruler. Police, prosecutors, and judges around the country will have to recalibrate to a reality where springs and followers don't convert peaceful owners into criminals for daring to load past an arbitrary line. If the court declines, or worse, rubber stamps the Ninth Circuit's contortions, then you can watch the permission slip model metastasize. More legislatures will discover that calling round 11 dangerous is a quick political high with no constitutional hangover. You'll get a map of rights by zip code, a patchwork where the same magazine is fine on one side of a county line and a crime on the other. That is not federalism. That is abdication dressed up as local control. There are doctrinal questions the justices must answer clearly. What does common use mean? And who decides? Owners or officials are detachable magazines. Arms, or do courts get to pretend a core? Integral component is a mere accessory. If history matters, how close must analogs be? Exact, near exact, or whatever a creative lawyer finds in a dusty ordinance about trap guns and Bowie knives. The coalition's position is simple. Stop the lawyering around it. Common ownership of standard gear plus no tradition of capacity caps equals protection. Could the court try something narrower? Sure, it could swat down California's cap while writing a footnote that leaves room for targeted rules in sensitive contexts. Or it could remand with instructions that virtually guarantee the same result. But the message still needs to be unmistakable. You cannot smuggle ban logic through the back door of public safety. Safety is a noble end. As a constitutional tool to erase rights, it's poison. I've heard the talking point that nobody needs more than 10 rounds. Needs according to whom? The judge in chambers or the family in a house where help is 20 minutes away? The word need is always the siren for rationing liberty. We don't ration press pages, sermons, or defense counsel by government opinion. We don't ration round counts either. Capacity is not cosplay. It is preparation for the worst seconds of a life you hope you never have to live. 11 is not evil. Erasing it is. That's where I stand, Mamishkia. The Constitution doesn't ask for mood lighting or permission slips. It demands fidelity. If the court speaks with that kind of clarity, the bans fall and the message travels. Rights are not regional privileges. If the court hedges, the confusion spreads and the bureaucrats celebrate. I know which of those futures is worthy of a free people. Sound off. Share your view and stay engaged. Stay safe, stay vigilant, and stay free. Keep your voice heard.